So just going to talk very, very quickly about our own experience in the small firms, sort of what are our top three queries in relation to. So the number one is data access requests. We get these pretty regularly every week. And from our own experience, it's been from usually internally from employees who are using it as a form of discovery to get access to their data. So it's really something not to be ignored. And I'm going to take you through our 8-step guideline on data access requests. The other one is retention of records. We get a lot about that. How long do I have to hold it for? Is there a specific timeline in the GDPR? There isn't. It depends on what the purpose for. But there are certain pieces of legislation. We do have some resources on record keeping, particularly around HR records. So you can go on there and check that out. We have a webinar on that. So just if you want to refresh it. And again, each year you might want to refresh your HR records so that, to check and do you need to keep that data. And then finally, the third one is data breaches. We do get a lot of queries around that. Whether it's a risk of it, and we can answer questions about that later. So just to move quickly on to our 8-step guide to managing data access requests. So the first step, we'll just do a quickie overview. The fee no longer applies. You have 30 days, the 1 month to respond. You can request to have an extension, but what I would say is that to just to understand that, to let the person know, but I'll talk about that later on if you need extra time. If somebody sends you a data access request by email or electronic format, you must send it back in the same. You may charge a fee if it's excessive, but you need to be able to establish why you're doing that. And you may have grounds to refuse it if it's unfounded or excessive. However, again, you need to state that clearly in your policy on data access requests. So that's just a quick overview. So the first thing is to educate your staff. What does a data access request look like? And where will it come from? So these are things just to think about. So thinking about email, web forms, possibly social media channels. I want my data from a tweet, letter, over the phone or in person. But again, I would, if somebody's coming asking, well, I want all my data, I would get them to put it in writing, either by email or some form. And then finally, via a solicitor who is representing the data subject. Now, what I would suggest on that piece is, if you get a letter from the solicitor, do get some documented evidence to prove that they are acting on the authority of the data subject. So something from them to say that this person has consented to that. Don't just hand it over before you get that. So the other thing is to ensure that all staff are aware of how data access requests come in. So maybe mention that in your data access policy. And who is the central person who deals with these. So the next step is verify the identity of the data subject. Often you'll know who it is, whether it's an employee, but in some cases you might not. So you might want to get some form of ID to prove they are who they say they are, because you don't want to give somebody's personal data to the wrong person when you think you're actually acting on a data access request. And again, I'm just re-emphasising the point, has the solicitor provided documented proof that the data subject has consented? And then there was one other quick thing. The other thing you can ask is there a specific piece of personal data that you want? If the person, that the data subject says, no, I want everything, then you must give them everything. But it is worth asking, is there anything specific they're looking for? Step 3, acknowledge receipt, that you received it. So the minute you get the data access request, do let them know, thank you, we've received this. This is who's going to look after the data access request. Again, check what is it they're looking for. Confirm an expected timeline. think of this person as your customer in a way. Don't just treat them as, oh, I don't want to deal with this, go away. Let them know throughout the stages, it's going to take us this length of time. If there's going to be a delay, let them know. If they don't know, it'll aggravate the situation even further. So the fourth stage, Donna touched on this earlier, and so has David. If you know where your data is, it's going to be so much easier to collate your data. If it's all mapped out, you're going to be able to respond much quicker. If you don't know where your data is held, it becomes quite problematic and it takes you much longer. So in other words, when you're gathering all that personal data, I also put a note here. Personal data is any information that is related to an identified or an identifiable individual. So this includes electronic and hard copy. So you might have a notes about somebody. You might have their name, or it might show that it identifies a specific individual, say things like disciplinaries. You may have to hand that over if they're asking for all of their personal data. So areas to look for if you don't have your data mapped out. So thinking about your employee HR files, accounting systems, documents where the data subject is identified, referenced, i.e. CC mails, emails, letters, messages where they're referenced, CCTV images. If somebody's asking for their CCTV image, again, maybe just ask them the date that they were in, just to try and narrow down that search. Call recordings, biometric data, CRM systems, newsletters, marketing tools, and then again, Donna mentioned your data processor or controller, so third-party providers. So consider if any exemptions apply. There are certain exemptions. There's more detail. We have this 8-step guide up on our website, but I realise time is ticking on. But it's quite in depth there, but there are just a few examples. So if there's a legal claim or there's a potential legal claim, you could potentially not have to pass on. That may be an exemption. Civil law claims, claims for damages, anything around the administration of tax, duty or other money to the state. But you can see that in full, or I can email you a copy of it tomorrow if you want to get in touch with me. So then steps 6, 7 and 8, redact, review and issue. So redact out names of other people in the personal data that you're collecting, where, say for example, an email where somebody's referenced, other people are referenced, you need to take their names out. It may be tricky with CCTV footage to redact out other individuals, but that's something that you would need to do because you can't have other individuals there. Get a legal advisor or whoever's responsible for the data protection in your business, whether it's a DPO or you might use an outsourced DPO, to review the documents before issuing them out, and then issue the response letter and the requested personal data. Now, there are certain elements in the letter that you need to refer to when you're responding to the data subject, and it's the purposes of processing, the categories of data involved, to whom the personal data has been or will be disclosed, whether the data will be or has been transferred outside of the EEA. Think about the UK possibly could become a third country if Brexit happens shortly. The period that the data will be stored or the criteria to be used to determine the retention periods, the right to make the complaint to the Data Protection Commission, the right to request rectification or deletion of the data, and then their right to restrict or object to the processing. So as I said, we do have a copy of this 8-step guideline that you can get on the SFA website.